How is the court aggrieved?
My lord,
How is the court aggrieved?
they agreed because, my lord, the notification which was, my lord, set aside. That is, my lord, that was in the consent of the because by the government, my lord, at the consent of the High Court, my lord, that was issued, my lord. So now, my lord, because of this, since it is no more, my lord, then, my lord, all commercial matters stand still, my lord. So that is why, my lord, even the government also not done anything till today.
No,
For that reason, my lord,
but the consultation process could have been started by the state. We have
we have made a statement, and that, my lord, till today, not done anything, my lord. Paragraph 5, my lord. In that way, High Court agreed, my lord, because the order which was, my lord, that which was, my lord, set aside, and that is, my lord, in the consultation with the High Court, as per the Act, my lord.
yes, Sarma.
I'll leave it to lordship, my lord. As far as the notification is concerned, my lord, notification was passed on the basis of an ordinance, which was not there, because the civil clause is only up till 2015, which your lordship in para 13 have rightly indicated. Now, only thing is that, my lord, that since there is no notification as on date, there is no commercial fee. That is the difficulty.
My lord, in fact, my lord, if your lordship, my lord, page 21, that's order, my lord, or notification, my lord. Instead of ordinance, my lord, only one, if it is stated the Act, my lord, everything will be clear. Only that word, my lord. Your lordship kindly see, man, in 18, my lord, 2018 is it amended? Yes, if it is as per amended Act, then everything will be resolved, my lord.
It's a part of our duty to also
Yes,
see
correct, my lord. That
also
absolutely,
see and interpret common stuff.
my lord. As I understand, my lord,
There are
only that
judicial
word, my lord,
pronouncements.
instead of ordinance, it should be, my lord,
There are judicial pronouncements also discussing on common full stop.
my lord.
So, Mr. Savala, it has affected the trial court.
Yes, basically, trial courts are running, my lord, on the basis of the earlier notification, which is no longer into existence. Still, we are filing cases before the civil justice.
But the general, my lord, suit is not a commercial suit.
Otherwise, also in Assam, what I have understood, my lord, most of the cases are running like a normal civil suit, even though it is designated as a commercial court or a commercial procedure. Well, may I suggest one thing? I have gone through some of the notifications of different states. There, what they have done, they have categorized by value. So I don't know if my lords can do it or with consultation with the.
No, that on judicial side we can't do.
My lord. Yes, I have seen, my lord, in Kerala, I have seen, my lord, very distinctly.
No,
my lord.
but what you are suggesting appears to run contrary to the Supreme Court judgment.
My lord.
JC Cement.
Yes, sir. That is there, and also, my lord.
It says there cannot be two forum. Very categorical
My lord.
judgment. Yes. Hmm?
I don't have much to say in this case, Your Lordship. I don't have for exponent number 2.
Okay, we'll examine and pass orders.
My lord.
Learn counsel. Also, let me say, learn counsel for respondent number 1 and Mr.
And the stuff.
And then the third and counsel for respondent number 2. Permissions have been read. But we'll do that. Only just record the names.
Deeply.
What had happened was that give me the record. Record. Okay, it'll come. I'll send you because they are just comparing it. There are some corrections which are being corrected. What has happened here? The DW1 and DW2 gave evidence on affidavit, but when we went to the opinion, there were 4 DWs. So therefore, we examined why it is so. The record contains only 2. Then we found out that the oral statement of the same witnesses were taken. Now DW1 becomes DW3 also in oral statement, and DW2 becomes DW4. And then in the order sheet, it is not mentioned that anyone, the GP was there. Just give it to her. The GP was present to cross-examine. So therefore, the renumbering of the witnesses is something which are just see the order sheet. Order dated 4/2/2020.
Yes, Lordship.
4/2/2020 and 20/2/2020. These are 2 orders where it is set fixed for
Cross-examination.
yes.
Yes, Lordship.
Now, the statement of the witness is there down below. This 20 February 2020, this cross-examination took place. Just is a
The order, I have seen the order sheet, Lordship.
that the
2020.
the statement is down below.
Yes, Lordship.
No, it's quite below. Yes, somewhere there.
Statement of
DW1 and 2.
DW2 evidence on affidavit account.
No, after that. 2 pages after that you will get it.
Yes, Lordship.
Now you see this DW3,
DW.
4-5 lines from the top.
I have found 3.
Three. So it's the same witness recorded as 3.
3.
Now this does not say cross-examination,
Yes.
correct? Now please come to the opinion. Second last page, down below. It will get this will be more convenient. You can see from here, it will be more convenient. It will be a second page.
Paragraph 11, Lordship is referring to paragraph 11.
Yes, second last Second last paragraph. Page 78,
Yes, sir.
last part you will find
The reference case are based on doubt.
Proceeding herself made an oral evidence at DW3 and the evidence on affidavit of DW1 and her mother evidence DW2 and DW4 are all perused. So therefore, in the order it is cross-examination and here it is oral statement.
Yes, sir.
But for this procedural part, we set aside and send it back. We are relying on the ECR and SR on public document. There's some corrections will take some time to upload it. The petition is allowed by setting aside the impugn order and the matter is remanded back for a fresh opening by the learned tribunal. You are directed to appear before the tribunal on or before the outer date of 31/8/2026. Please note it down. And you will have to take bail, which will be valid for a period of 30 days after passing of the impugn opinion.
Lordship, on Flare, Lordship, regarding the item number 3, my lord. So I want to go through the report only.
Okay.
And mention? Yeah, please. I get to mention for, I think 30 years or so. Maybe this matter may be taken up after motion matter here also. So I think it will be.
We'll try to see, we don't
Yes,
assure you
yes.
because we'll be rising early.
This is an expertise order.
Expiry for Lordship is 63.
These are all will be taken up today. We are not jumping sequence today.
Okay, I will miss you. To take over.
Hello, ma'am.
So Lordships, for item number 20, I'm kindly seeking for an adjournment as the conducting counsel is out of station.
No, this is 21 matter. We are not adjourning any matter today.
Your Lordship kindly allow for a day or adjournment.
You may renew the prayer when the matter is called.
Yes, sir.
We're not obstructing any matter today. Mr. Huda, you are sitting there for which item? We can upgrade and take it up.
That's fine.
I think item
Item 4 and 5.
Item 4 and 5. We'll take this first.
yes, sir.
On the government, Lordship left this matter to the, to get the order.
We just examine.
Lordship item. Lordship, can it go with the matters listed today? Yes, that is right. So this can be tagged to those matters. And the second one, Lordship, the second one is also ex parte, Lordship. 4 and 5 both are ex parte orders. Yes,
Lordship. Lordship, my actually anxiety is, these two actually have the husband and wife, they are languishing in actually general camp. And not known to them at any moment that there was a case against them before the tribunal hold. That's it. Yes, that's it. Near Goalpara, Matia, that country. So my anxiety is only to the plight of this persons. We have all backgrounds that legacy, that some persons are there and all these things. But even then, now, ex parte order, they are poor men, they are exhausted for livelihood, near Nagaland, they go to Nagaland, cultivate there, earn something, stay there, having their all kitchen things, that Sapormo, Lumramo, and all that, all things are there. But even then,
But Mr. Huda, you have a wonderful reputation. Poor people will not come to you. You have a very good reputation. Poor men will not come to you.
No, that's the reputation and all things are government, the celebrities. This present juncture is very critical, so in every moment, everywhere.
But the notice was served. What is the explanation of notice not being served?
Notice may not have, they are illiterate person, they don't know how to write. This is the Gambura, local Gambura says that I know. That was notice, that is expressly notice. That was actually become the subject of in the tribunal, very tacitly. And the apex court, whichever this has been built, I am not accepted with that apex court, all these things before your lordship is aware about all. And it is the lordship who will actually run me believe if lordship should be there. The basis is the apex court judgment that I have supplied before your lordship on that day. And it has been left to government to understand the guidelines. Yesterday also I understand that the ministry also has something yesterday in the TV, and the TV I have also seen all these things. But also grant this sort of relief, unnecessary harassment to persons who are actually not properly taken up to be guilty of foreign aspects.
No, but you see, if people do not come, we'll have to pass ex parte orders. That is the law.
Item 4, the notice was received. by
And the second part is, Mr. Huda, which you will have to make your submissions. The judgment of this Savitri Day, it does not lay down the law that in every case this ex parte opinion has to be set aside. You see, we are not commenting on the Supreme Court order, but if the burden of proof is on the petitioner and the petitioner does not respond and does not contest the proceeding,
My ex parte order, lordship, I believe that lordship will be in a position to understand me in this matter. That since it has become an ex parte order, I should be at least be given a chance to appear before the tribunal to produce my bona fide, whatever I have at my own as a citizen of India. So apex court, whichever in a way the apex court has observed, and this has come out in this aspect that I have to be communicated to government also on that day. And lordship may have actually next time may be pleased to done me at least to appear before the tribunal and prove by identity and all in view of this apex court.
We have a doubt, you'll have to clear it. Please come to page 18. So you can sit and make your submissions, no problem with that. You can sit down and make your submissions.
Oh, no, that's what I was.
Okay. Page 18.
18 is in Assamese version.
No, it's okay. This is Dilwara Khatun. The signature is there in the top, left hand top.
Her signature.
This is not our signature.
It is not her signature.
No, it's okay. Whatever is there, the signature is there and signed in presence of Gambura. You see the signature of Gambura, the name is Nazrul Islam Chaudhary.
The Nazrul Islam Chaudhary.
Yes. Now please come to page 32. Now 32,
Okay.
the Gaon Pradhan
Yes, Nazrul
has
Islam.
given his, but this Nazrul Islam, but Chaudhary is missing.
Yes. Nazrul Islam.
But that in the earlier document it is Nazrul Islam Chaudhary.
Huh?
We made him party here.
Yes, yes. We have made him actually party. He is a party.
And by representation.
Page 42 is represented.
Okay. We'll hear Ms. Verma.
Lordship, we can hear them together with,
Yes, yes.
those matters are listed in the admission column, Lordship. So this can also be heard at the same time.
You can permit Mr. Huda to leave. His assisting counsel will be here.
Yes.
We'll hear it together, Mr. Huda.
Okay.
We have heard your submissions. Your assisting counsel can be here.
Yes, yes.
You can leave. And in item 5,
Same Lordship, husband and wife.
husband and wife.
Yes, sir.
Okay. Okay.
For motion item 1.
Mere pleasure, Lordship.
Yes.
Lordship, yeah, your lordship, I agree that case, your lordship, to be very honest, your lordship, because not a single document has been exhibited, your lordship, by the petitioner, your lordship, at the before the tribunal, your lordship. So, your lordship, so this lapse, your lordship, not because of the petitioner, your lordship. It is the lapse because of someone, your lordship, someone from my same fraternity. Though I'm not wishing to point out that, your lordship, but your lordship, apart from this writ petition, your lordship, I have a prayer, your lordship. That is, your lordship, because the petitioner belongs to Hindu community, your lordship. So, your lordship, there is a provision, your lordship, in the Citizenship Amendment Act, your lordship.
So that you can do at your own. You don't need an order of the court because the court cannot give an order. There is a full bench decision.
Yes, lordship, but my prayer, your lordship, with due respect, your lordship, if lordship is going to dismiss this petition, your lordship, a liberty may be given, your lordship. That is my prayer, your lordship.
That can't be given. We can't override the Supreme Court judgment. Supreme Court says that declared foreigner will not get the benefit. So we can't give that liberty.
Lordship, lordship, otherwise the act, your lordship, the 6B provisional part is.
No, that you
they
can
are
do
lordship.
of your own, but
Lordship.
it has been interpreted by the Supreme Court. We can't travel beyond. We can just accommodate you with a small short adjournment for 2 or 3 weeks, nothing more.
Lordship. So, your lordship, I have nothing to submit in this case because not a single document's been exhibited, your lordship. So, lordship, except the pointing out the fault, your lordship, from my same fraternity, yes, I don't wish to do so, your lordship. So, your lordship, I don't feel to argue this case on that this arraignments, your lordship. So that is my prayer, your lordship. It was lordship is granting you 2-3 weeks to approach the. But one unfortunate part is this, your lordship. I can't even reach out to the client, your lordship, since long, your lordship. So 2019 case, your lordship, in the year of 2019 also she came, your lordship, submitted her documents, even originals are also there in my hand, your lordship. But I couldn't even reach
No,
out.
but
your
the
lordship.
problem is that you don't want to antagonize you don't want to say anything against the lawyer. You don't give a complaint before the bar council.
He also
You-
expired, your lordship.
You patronize them,
But lordship,
and then the ordinary people are victim.
he expired, your lordship. The lawyer, the engaged counsel of the before the tribunal already passed away, your lordship. Lord, the Lordship, if it gives the opportunity of 2 weeks or 3 weeks, Your Lordship, I tried to reach out to clients, Your Lordship.
Lordship may give
So
her
that-
a last chance to reach out to the client, otherwise Lordship will take it up on merit. That is the best we can do because it's of 2019. Already so much time has passed by.
Seven 2026, last chance was granted to the petitioner. And it was made clear that no prayer for adjournment shall be entertained. The learned counsel for the petitioner has renewed the prayer for adjournment on the ground that despite her best efforts, she could not reach out to the petitioner. In such subject, it matter is relatively adjourned. That it will make clear that the no further adjournment shall be granted on the next date of listing. Next list on your date after 3 weeks.
Much obliged.
Lordship has fixed the date.
24 of us.
Much obliged.
Item 2.
Lordship, this is also an ex parte.
Ex parte.
The last occasion, I even some my submission. Lord, while giving opinion, my lord, is a verification report of the police, not really considered, my lord. Because my lord is the verification report, my lord, page 26, annexure 8. Date of birth is, my lord, 1965 is mentioned. In that, my lord, the verification, it's serial number 16. Place from where migrated. Whether migrated before 1166, between 66 and 71, all these are mentioned as nil. Reference by SP, page 30, serial number 5. Also, age is taken 1965. That mentions suspected foreigner. Last occasion, your lordship pointed out me, my lord, that there is no legal submission, my lord. I, my lord, submit, my lord, the Citizenship Act. Citizenship Act, section 3, my lord, citizenship by birth. Acquisition of citizenship, citizenship by birth. Every person born in India on or after 26th day of January 1950, but before 1st day of July 1987. So if it is so, my lord, then opinion is not correct. Because my date of year is taken 1965. My second submission, my lord, section 6A, a specified territory, C, means the territory included in Bangladesh immediately before the commencement of the Citizenship Act 1985. Here, my lord, in serial number 15, where from migrated is nil. Page 27, serial number 16. Apart from my lord, this document, because it is a expertise, I could not submit my lord. But from the police, my lord, verification and from the reference of the SP, these things, my lord, come into my lord notice. And my lord, so the opinion that a petitioner is foreigner is not correct opinion.
Okay. Okay, please wait, because they will respond together in all the matters.
Lordship,
And which paragraph is your explanation of the notice in your writ petition?
My lord, lordship last occasion is shown, my lord, his signature is there. So, my lord,
No, which paragraph is your statement? Let us see that. Paragraph 13, 14.
yes, my lord.
Okay.
Yes, my lord, in paragraph 13, statement is there.
Paragraph
Paragraph 13 is there.
13, 13, 14. Okay.
Lordship,
Next.
just one submission. As per his own affidavit, his date of birth is 1973, Lordship.
70.
1973, because he's 46 years in the year 2019. So, but in the police verification form, he has stated that his date of birth is 1965. There is a contradiction here.
Okay. Next.
2019 is 36 years. I think he might have to 6 years out of the year. 64. Yes, 62.
Item 3.
Okay.
Parlo ko chahiye, हाँ, इसमें. Actually, amount that we file 9. It is expired. Lordship, item 3 is also ex parte, Lordship. Lordship, I'll have to submit from the records because I don't have a copy of the petition. Yes, my petition.
This is an ex parte opinion, my lord. Initially, petitioner received the copy, my lord. After that, he appeared.
But in this case, Ms. Verma,
Yes, Lordship.
please come to the opinion at page 29.
Yes, Lordship.
Give her a copy.
My lord, I have also not the copy.
You don't have a
I have
copy.
taken note.
Okay, it would do.
Whatever your opinion.
29 is the opinion. It is ex parte. Next page you will find page 30 is an application for review.
Review, yes, Lordship.
This on the left side you will find 19.6. So it is filed within 1 month. And then if you will come to
Order of the review.
order of the review,
No, it's okay. I put.
At page 39, Lordship. Order of
39,
the-
yes, yes.
The case is taken for the order to investigate.
I think in this case, he has made out a case.
Yes,
The lawyer, next page, come to page 40.
yes, Lordship.
The question is whether not informed by the engaged lawyer to the petitioner is a sufficient ground.
For setting aside the expert.
I think he has immediately after he has come to court. He has shown no negligence. It is a set for you. Huh? No. नहीं तो को नहीं ना थोड़ी सी hearing September.
Lordship, it is the duty of the petitioner also to keep himself informed about
We
the
understand,
matter.
but
We can't completely blame the lawyer on this aspect because it is his burden. His citizenship is more valuable to him than the lawyer, Lordship. This excuse cannot be taken so lightly, Lordship.
we understand, but
And
the
he no urgency. See, Lordship will notice 2019 matter. He has never come before this court to mention that my case is pending, it may be heard. He has never approached Lordship,
so-
and you have to look at that conduct of the petitioner also.
So many
Because
cases,
can't
they
do
have
anything.
history, they don't want to come. 6 years have gone here, Lordship.
he's interim.
we can't help with that.
He's an interim Lordship.
No, that is why he has not come, because he's on interim.
Not only my case is pending, but so many cases pending since 2019, my lord.
So, but
motion
any
is just-
if urgency, you could have,
motion-
that is what I'm trying to tell.
The
I'm
motion
But
is-
still,
suggesting
that,
no urgency in this
at
matter.
that point of time, if she has come on time, then there was no negligence. So, I think with citizens side.
It is a good day today if this matter is being remanded back. In between, if Lordship remembers 2019-20 matters, opinion passed then. They're filing the review in 26, 25 only for the purpose of bail. That has also, we have seen so many such matters also.
But that's true.
So the urgency arises only when they are arrested or when the police is looking for them.
That's true, we can't help it.
But Lordship, we cannot allow them to,
You
if
see-
it continues, then it will become a habit.
You see, about 5-6 months back, I was told that there are 200-300 cases, 200 to 300 cases of 2019-20 pending. I've been taking up and then still cases are coming up.
Lordship, many more will come because that was the time when NRC was at its peak, Lordship. They could not produce documents. It is that time when they came out with all the ex parte orders and the declared foreigner orders. And the court
that's
was
okay.
flooded. I think we had the maximum cases in those 2 years, 19 and 18, more than 5,000 cases. I was myself handling so many cases. They suddenly woke up when the NRC process started. And now because the arrests have been coming up, now again the court is flooded with these matters. The previous matter, 22 opinion, they never came
No, but-
before this court, only when they were
Within
arrested,
ex parte,
now they
the-
have come.
Within ex parte, this petitioner came in within time for review also and before this court also. The order was passed on 30/10
Yes, Lordship.
and this review was filed, this petition was filed on 7/12.
They have, in this matter, they have come before this court on time, but the usual pattern, this is their Lordship.
Order was not later, but the petitioner was before the court within 1 month.
Yes.
1 month, sir.
1 month. अभी किसी को पता है?
So,
Take this.
order is before me.
Heard. Mr. F. A. Hassan, counsel for the petitioner and so for the respondents. Next one. By filing this writ petition in Article 226 of the Constitution of India, the petitioner has assailed the ex parte opinion dated 24/5/2019. Page 29.
Yes, 21.
Passed by so and so in case number so and so, police inquiry number so and so, by which the petitioner declared to be a farmer post 25/3/91 1971. Next part. The next part, the petitioner upon coming to know about the ex parte opinion dated 24/5/2019, filed an application for setting aside the ex parte opinion on 19/6/2019, wherein it is projected that the petitioner took steps through his engaged counsel, but he was not informed of the next date for filing of the written statement, and accordingly, the petitioner paid for setting aside the ex parte opinion. Moreover, on the same date, i.e. 19/6/2019, the petitioner had also filed a review petition against the ex parte opinion before the said learned tribunal. Next paragraph. The learned tribunal, by an order dated 15/10/2019, rejected the application for review not review, set aside of the ex parte opinion. Thank you. Page 35. Itu procedural review, paragraph 6 itu consider review. Next, learned tribunal by an setting aside application on 19/6, which was registered as miss case number 6 of 2019. And this review petition was recorded as petition number 376 dated 19/6/2019. It was the learned tribunal by an order dated 15/10/2019 was of the view that as the petitioner appeared before the learned tribunal on 5/2/2019, and since 13/2/2019 to 2/4/2019, steps was taken by the learned engaged counsel, but since 17/4/2019, the petitioner was absent without steps, and the ex parte opinion was passed on 24/5/2019, and accordingly, the learned tribunal was of the view that the blame on the engaged counsel was not a sufficient ground for setting aside the ex parte opinion. Next para. The learned counsel, learned study counsel for the border and FT matters has was the prayer for setting aside of the ex parte opinion on the ground that the learned engaged counsel for the petitioner was had taken steps, but thereafter, as the petitioner did not take steps, the petitioner as well as as his learned counsel had defaulted in further appearance, and therefore ex parte opinion was rightly passed. Next para. In this case, on examination of the travelers' records, it is seen that though the ex parte opinion was passed on 24/5/2019, but the petitioner had within a period of 30 days, filed two applications, one being this case number 6 of 2019 for setting aside ex parte opinion under Order 9 Rule 13, read with Section 151 CBC, and the other was a review petition which was filed by petition number 376 dated 19/6/2019. Moreover, on the dismissal of the this case 6 of 2019, the petitioner had to close this court within a reasonable time as the application was filed on Seven 12/2019. Next, in this case, the petitioner has also carried the responsibility, the learned counsel who had defaulted in informing the petitioner about the next date as respondent number 7. Next para. But the ordinance within bracket travels bracket was order 1964. For the same permits the learned tribunal to set aside the ex parte opinion under order 3-C thereof. Next para. From the fact that the ex parte opinion was passed on 24/5/2019, And the petitioner could file a review application and an application for setting aside the ex parte opinion on 19/6/2019. Apparently discloses that the petitioner was pursuing the matter. Otherwise, he would not have and that is why he could, the petitioner could file the application, the set to application within a period of 30 days. Time allowed under section, under order 3, capital C of the foreigners within bracket travelers, because order comma to 1964. Next, accordingly, comma. In spite of objection made by the London Standing Council for the Border and FT matters from quarters of the constitutional opinion that the applicant, the petitioner has been made able to make out a case for interference with the ex parte opinion Ms. Verma, there is something you have to examine. No, deputy commissioner, India to the article result. I don't listen to the commissioners. There's something which you'll have to flag. You have a copy, you don't have the
I
petition.
don't have it. I will
Then,
send it back to lodge.
then you better look into this document. It's at page 21. This is something where we had to stop and check. This will also require the central government. Central government, who is there? They're there for the central government. Look at this document, page 21. Go to central, citizenship is a central.
Nikhil Chandra nomination. And that's from Tripura.
It is the prerogative of the central government to, for a declaration of citizen. And there is no record of the deputy commissioners being empowered to give a certificate like this.
Mhm.
So both of you will have to take up this matter when,
Lordship, here the name is Nikhil Chandra Namasudra, but here the petitioner is Nirmal, alias is Nikhil Namasudra. He may be the same person, he may not be the same
may not
person.
be same, but this document will haunt you otherwise.
Yes, Lordship.
This,
This is of 1986.
in 86 also, this citizenship is something which is vested only in the central government.
Mm.
The deputy commissioner cannot start giving a, you see the language, please read the language. He qualifies to be a citizen.
Citizen of India.
That qualification certificate cannot be given by a deputy commissioner. This is wholly illegal.
Lordship will get our instructions and let the central government also get it.
Hmm?
We will get our instructions and let the central government also, because it,
No, because you see, we will not adjudicate on that document. We are
Yes.
just flagging it to you so that when the tribunal, the hearing starts, you'll have to flag it to the Home Department and
and submit
Examine
the
this
statement
document.
of PSO.
examine this document here.
Document. Lordship may indicate it in the order also, Lordship.
So then it would be examination of the order. That in statutory we won't do it.
No, Lordship may just indicate that this document may be,
Either will, referring a document will not help the order. It will either be in a
Lordship, because
affirmative.
so, I understand Lordship's concern, but we will also have to send a copy to the government advocate there informing about this. And by the time it reaches, we will also forget, Lordship. It happens, there's so many things happening every day. Or in a separate thing, Lordship can look at the direction.
Okay, we'll make it away. Go to the- you go to the- go to the- and we will. Kindly follow the reporting.
Because what we need is another one.
You know,
So, yeah. I don't know if it's possible.
even if I put the rule for order, she thought,
Copy तो हमारे पास ही है।
what could be your objection that this document is appears to be doubtful because
आगे आगे से जो खाली लगे।
into खाली जगह देगी. Okay.
यूनियन की तकनीक से यूनियन पड़ेगी।
Next. At this stage, the learned standing counsel for the border and active matters as well as the learned counsel representing the learned CGC have questioned the questioned Annexure 3 to the writ petition, which is a memorandum number 2123 oblique SDO oblique KMP oblique CTZN oblique 86, page 21, dated 29th April 1986, issued by the Government of Tripura, Office of the Sub-Divisional Officer, Kamalpur, North Tripura, within bracket citizenship section, certifying that the petitioner qualifies for recognition as a citizen of India by birth. And it is submitted that the said power is reserved only for the central government. Next one. In this regard, as the court is only exercising certiorari jurisdiction, the court would not examine the legality of document produced for the first time in the writ petition, as it would be the prerogative of the learned foreigners tribunals to foreigners tribunal to consider the same. Next, be that as it may, as the petitioner has been able to show that he had approached the learned tribunal within 30 days from the date of the ex parte opinion, and has also approached this court within a reasonable time. On court is of the concerned opinion that the petitioner has been able to make out a case for setting aside the ex parte opinion with an opportunity to the petitioner to contest the proceedings. Next paragraph. Resultantly, accordingly, ex parte opinion dated so is set aside. However, the matter is remanded back to the learned member, foreigners tribunal Roman 2, Haribganj, for giving an opportunity to the petitioner to file his written statement along with documents on which he intends to rely upon. So thereafter, the learned tribunal shall give an opportunity to the petitioner to file his evidence on affidavit, and the learned tribunal shall make an endeavor to dispose of the proceeding within the as far as practicable within the time allowed under Order 3 in bracket 14 of the Foreigners within bracket Tribunals bracket Close Order, 1964. Next paragraph, the petitioner, who is duly represented by his learned counsel, is directed to appear before the said learned tribunal within the outer time limit of 31/8/2026 and on the said date, the petitioner shall also file his written statement of defense and written statement along with documents on which he intends to rely upon. Next paragraph. Petitioner stands partly allowed to the extent as indicated above with an order of demand. As per the registry shall send back the travelers records expeditiously. There shall be no others to cost. Now recorded your statement so that you can now proceed the matter. We'll take a short break and come back.
For motion, item 6.
Your Lordship, the conducting counsel is engaged in court number 5. Kindly pass over to matter for time being.
You want to pass over or time being?
Pass over in time being.
Time being, sorry for time being. Time being.
Maybe taken. I'm just. Well, it may be taken up, okay, just as in quote, item 6. Yeah. We have made an application. Yes, madam. It's an ex parte case. In 2000, may I just summarize my case, madam? Just the facts of the case.
But that was decided by this court.
A single judge bench, Your Lordship, yes. That was upheld in 2010. Subsequently, another criminal case was initiated against me in 2016.
That's okay, but you see, under section 4, you, as an attorney, you'll have to be detained somewhere. You can't be let out on parole.
Now, my lords may kindly come if under the Immigration and Foreigners Act, section 7, my lords, which was the earlier section 3. I have submitted a compilation, my lords, in that page 117. The last occasion.
117.
Yes, madam.
Yes.
But, 111, madam, sorry. 111. Let me see, chapter 3, 110. Chapter 3, matters related to foreigners. Now, section 7. Earlier, this was in the Foreigners Act, section 3.
Yes.
So now, in the 7th, the detention or the power of detention is under section 7, in which the central and the state, two delegations exercise that power. The state exercise that power through delegation. Now, I'll just read the sections. The central government may, by an order or direction or instruction, make provision either generally or with respect to all foreigners, or with respect to any particular foreigner, or any specified class or description of foreigner for prohibiting, regulating, or restricting the entry of foreigners into India or their departure therefrom for their presence or continued presence therein. Subsequently, when they have, in particular, subsection 3, and without prejudice to the generality of foreign-going power, the orders or direction or instruction issued under the section may provide that the foreigners. Now, there's from A to F, there are conditions in which they can exercise the power. And what will be the nature of their power? Shall not enter into India, B shall not, I'm not reading the entire clauses. B shall not depart from India, C shall not remain in India, D shall, if there is any order or direction by the court that I need to, they will pass an order under D. E shall not remove himself. F, now F is what I am on, shall comply with such conditions as may be specified.
These are not applicable for a declared foreigner national. It's a misapplied argument.
No, why I say this, what is, I'll just I'll just summarize my entire case and then I'll just, from why I'm, before your.
This is it, this applies to a foreigner who visits India. There they can have restrictions that you will not go there, you will not come here. Those things doesn't apply in this case.
So, if the person has, if a state, if an authority has the power to detain, they would also have to have the authority to release you.
You can at best, you can file an application to be deported within a time limit out of the country.
I'll just, may I summarize my case for you? Just 5 minutes. Yes, what has happened in 1952, I'll just broadly summarize my factual metrics and then I'll come why I am before your lecture on the laws and then I'll come before why I am. So what has happened in 1952, my grandmother, Ribala Dasi, she came to India from East Pakistan because of religious persecution. That I have annexed 1952, she was issued a refugee certificate. That I have been annexed. I was born in India. That is my case. What has happened in 2007, I was issued an order to appear before the FP.
You see, we'll summarize what we want to say for you. In the judgment of the Supreme Court by a larger bench, a 3-judge bench in that 6A.
Yes, madam.
6.8 says, the second last paragraph says that the application for citizenship will not be given to a declared foreign national. And therefore, the prayer you are making at page 21 is contrary to the judgment in 6A.
May I just respectfully say, I submit this as an officer of the court, madam. In that case, what has happened, that respect is from my understanding, limited understanding, that was only with respect to the 6A2, which a single judgment says that if you are declared as a screen foreigner, you have to have entered into 66 and 70, and later you come before your before the High Court saying that the period has to be extended. That cannot be done. That is only a single bench has taken that. Honorable single justice has taken that opinion.
This was the law that if a full bench gives a decision and the single judge.
I know your law
countering
passed
judgment,
I know your lordship has passed the judgment. I'm aware of that. No, my order is that it is not my case that I come under 6. I come under 6A provision. It is not that my case. What I am trying to hamper here, is this, the order of the learned single judge. I'll just summarize the order of the single judge is hit by there is a change of law post 2010. 2015 notification was issued. In 2015 notification, if a person of a certain category were exempted, okay, now secondly, what has happened? There is a Savitri Day judgment because since initially it was an ex parte case. Now this has happened. Subsequently, the Honorable Supreme Court, the bail order was passed. Subsequently, there was another car came into force and Immigration and Foreign Permission Act came into force. All of these, I am exempted from them. So, in these circumstances, when there is a question of law involved, and particularly on your lordship's question on whether the larger bench, because I say this because I was also one of the many counsels who assisted. I was in the 6A litigation before the constitutional bench. This was actually submitted submitted before the constitutional bench that 6A will have some implication of the car, which will because that is already constitutional challenge is pending before the constitutional bench. In that light, it was assured by the court that this will not have any implication because it has also had to do interpretation with Article 11.
Get us a certificate from the Registrar General of the Supreme Court of India that this is the assurance given by the court.
I say with all honesty, my lord, I understand, my lord, all the difficulties, my lord. I just in case, and if my lord meets with the single judge bench, the Honorable Chief's judgment, it goes into on the Article 11 question. And it has nothing to do on that with car, because car constitutional challenge of car is still pending. Stay was argued, no stay was given, and I am not that, my lord. I am only seeking bail. Please allow me on bail. Because otherwise, Section 2 F order can be passed, my lord. My lords can direct them to pass an order under 2F, 7F. They have also not replied to my application.
You see, I also have made an application Incidentally, I am sharing it with you. But this is not for the social media. You see, that why not walk to the moon? And therefore, I made an application before all authorities that please permit me, please prepare a staircase from Earth to moon. I want to walk and visit. Nobody responded to it. Now, what can be done?
The law just passed an order in the last 5 minutes. They have to respond within 10 days.
We'll pass it for them. We'll take cognizance of what you're arguing. We'll pass for this.
And it is a humanitarian consideration, my lord. My wife is an Indian. There is nothing, my lord, that I have any
We can
threat to
adjust,
the
if
state.
you want, we can give you a direction that the government will take expeditious steps to send you back.
But they can't do that. They have submitted before the state. At least, my lord, may I just, may I just summarize my entire case, my lord? Please give me that opportunity, my lord. Otherwise, whatever your lordship decide, at the end, my lord, I bow down to them.
You see, is your prayer contrary to the second last paragraph of the 6A judgment by the Supreme Court?
So, my lord, if that question may be framed, my lord, and let me respond to that question, my lord. Let me find a
It is already
reply.
there, you see, question of law is a question of law. Why we need to frame it?
In the next time, I'll bring all the materials
And can't keep it pending for that.
and otherwise, my lord, also when just one thing, my lord, I don't have the order right now, but I have the honor, your lordship has taken a different view that this is a single bench order, single bench judgment is there and it has to be implied, it has to be read of the full judgment. That judgment has been challenged before the Honorable Supreme Court, and the Honorable Supreme Court has given a stay, and I can bring that, my lord, on record. Look at me, man. 10 years in detention, man. 10 years. They do nothing for my deportation. Now I come before your lordship. Your lordship is it's entirely detrimental to my case, man.
So why?
Your lordship knows, man. And I am not. I am eligible in the car. My lordship is preempting the other main problem. Difficulty is, my lord.
You can withdraw this and you can move the government. There's no problem with that. But if you insist on a prayer made in the petition, that is contrary to the Supreme Court.
May I reply only to that specific question and seek adjournment?
No, dispose it out.
Well, let me at least what they have replied. Let me see what they have replied to my. Let me respond at least to that one.
But you see,
Please respond that manner. See, at least that manner.
the matter is for there, you know what is to be responded to.
I have not. They have not communicated anything to me. No communication is given. They have to at least reply. Give a letter.
But you are an ex parte, no problem with that. We'll
Lordship, ex parte order pushed back, again came back to India. Again, there is an order of, under the Passport Act. So, after being declared, he keeps coming back to India, pushing himself back. We can't do much because except by
The law
keeping him
has-
in detention.
see, that
Lordship.
law has changed. There's a complete change of law. And on
Declared foreigner will remain declared.
but only on that ground. I want let me submit that. Sir. My lordship knows, my lord, the entire, I have not seen a day of the life. So if there's one opportunity that I have, my lord, I'm saying I'm almost drowning. So if a Pinka ka Sahara is also something, I have to catch in it. I know I might drown, and I'm drowning. Your lordship knows that. So that is my humble request.
We know nothing except the brief. Whether he is drowning or not is not a concern. The concern is that whether the challenge is in the present form is maintainable. You see, you can't wriggle out of the situation. When we were deliberating, you said that you are aware of the order passed by the court. You are also aware that the order of the this court has been stayed. So you are conscious of the fact of what we are deliberating on.
So let me, so that is why let me reply. Give those 2 days, 3 days time. Let me reply. Let me bring all of these orders for you. Let at the end, whatever your lordship decides, I bow down to that. Please see, my condition.
Miscarriage of justice. You can't start entertaining a writ petition after the writ petition has already been disposed of. The order of the order of this court of 25/6/2013, was it assayed?
2013
2013 order of this court in WBC 4607,
No, my lord. As per my understanding, no, my lord.
not been assayed.
No, they are otherwise single judgment. And so that is also valid. Now post Savitri Day, that has also been over. There is a change of law. So let me out. There is a delay of substantial delay. That is true, madam. Let me be out. Whatever condition, 226 has an ample power. Now let's see, let's Foreigners Act doesn't have any power. Let's, for the sake of an argument, let's assume it. But in spite of that, 226 has an ample power.
We'll see, we'll examine if it can pass.
There's just also one thing, well, just one thing, last thing. All of these matters, was the petition was filed 2019-1045, which was in which the Honorable Supreme Court passed the order of giving bail. The Honorable Supreme Court, they were aware that the state is not going to release them. And this is pre-COVID. Post-COVID, there was a change. My Lord knows. So, and that list is still pending before the Honorable Supreme Court. So, that is also something, because the Honorable Supreme Court knew, and they exercised, it was a 32 petition. A private respondent approached the Honorable Supreme Court. Later, the respondent was there, and the Supreme Court Legal Service Authority was appointed. So, that is the gravity, because the Honorable Supreme Court knew. And I release you on that condition. I won't leave the jurisdiction. Because my family is here, I am not a threat. So that is also one of that has to consider. And my lord, just also one thing in the compilation, the single judge bench in a different matter has passed an order releasing the person on bail. I have annexed in the statutory compilation, that is 12th number, page 207, Deepika Sarkar versus Union of India. Similar facts. Honorable single judge, they give me bail, give her bail. In the compilation, page 2007. Minutes. If I lost on 2000, page 2007, there is similar facts, minutes. I'll just read the order. 208 minutes. Of the line is single judgment. The father of the writ petitioner, namely Chitanjan Sarkar, was subjected to a proceeding before the Foreigners Tribunal so and so, corresponding to so and so, and police case so and so. In the proceeding before the Foreigners Tribunal, the order dated to so and so was filed, by which the petitioner was declared foreigner to be a foreign national who entered into Assam after 1971, and thereafter has been legally staying in Assam. Correspondingly, the petitioner was also subjected to a proceeding under Section 14 of the Foreigners Act for having violated Good India notice, which resulted in GR case number so and so before the learned CGM Kamrup, Gauhati. By the judgment dated 30 so and so, the father of the petitioner, Sri Chitanjan Sarkar, was held guilty of an offence punishable under Section 14 of the Foreigners Act, and accordingly was convicted and sentenced to undergo an imprisonment for 1 year and 6 months. On an appeal being carried by Sri Chitanjan Sarkar before the Additional Session Judge number 1, Kamrup, Gauhati, which was registered as criminal appeal number 55/2012, the conviction and sentencing by the learned Chief Judicial Magistrate was upheld. In this resulting situation, the petitioner served out the sentence of 1 year and 6 months, and his sentence came to an end on 8/11/2019. Due to the serving of the sentence, the father of the petitioner, Sri Chittaranjan Sarkar was lodged at Central Jail at Gauhati. After he completed the sentence, he was shifted to the detention center attached to the district jail at Gwalpaya, and since then he is in detention. Second, the learned senior counsel for the petitioner relies upon the pronouncement of the Supreme Court in its order 10/5/2019. Now, this is the first order before the COVID hit. 10/5/2019 in writ petition 1045 2018, wherein the flowing order was passed. In so far as the release of detainee who have suffered long, I'm not reading the entire order, the Lordship knows it. The second, the fourth, reliance has also been placed by the subsequent order dated 13/4 in suo motu petition civil number 1 of 2020, wherein the earlier noted with 10/5/2000 stood modified to the extent that the period, now this is all the modification that the Honorable Court notes. Now, subsequently, it is the contention of the learned senior counsel for the petitioner that Sri Chittaranjan Sarkar has completed 2 years in detention, and therefore he is covered by the proposition of the Supreme Court, as provided as the order of 10/5/2000, which stood modified by the order dated so and so. The respondents have not contravened the stand state. Now, the respondents have not contravened the stand. So this was not at that point of time contravened by the respondents. So it can't be their case now. Of the learned counsel for the petitioner, Sri Chittaranjan has completed 2 years as on in detention as on today. Second thing, the only stand taken by the respondent in the affidavit in position is that the case of Sri Chittaranjan Sarkar for being released is being considered with other similar person, and therefore it is under process. So in this case, they were under process, they accepted it. Even if we take into the consideration the release of Sri Chittaranjan Sarkar is under process, we took note of that the said affidavit was filed by the respondent number 3, who is the Secretary of the Government of Assam in the Home and Political Department, and it was filed on so and so. More than 45 days having elapsed since the filing of the affidavit, we are of the view that in the meantime, the situation of the matter being under process must have come to an end by now. But it is stated on behalf of the petitioner that the detainee so and so has not been released as on today. The order of the Supreme Court, now this is the observation, the order of the Supreme Court dated so and so is apparently clear that in respect to all the detainees who have served for 3 years, which again stood reduced to 2 years by the order dated so and so, are entitled to be released again on the conditions stated in the order dated so and so. Considering the matter in entirety, we are of the view that Sri Chittaranjan Sarkar is entitled to be released from detention as provided by the order in the order of the Supreme Court dated so and so in so and so, and the order dated so and so in suo motu so and so. Accordingly, the respondents are directed to release the Sri Chittaranjan Sarkar from detention at the detention camp at Gwalpaya forthwith. In doing so, the detainee shall execute a bond of rupees 5,000 each of 2 sureties of the like sum of any Indian citizen to the satisfaction of the CGM Gwalpaya, which shall be verified by the respondent authorities as provided in clause B to E of the order of the so and so. The detainee shall again be vouched by the additional police whose shall again be vouched by the writ petitioner Srimati Deepika Sarkar, who shall specifically verify the address of stay of the detainee after being released. The biometric of the detainee as well as his name, fingerprints and photos shall be captured and stored in a secure database before being released from the detention center, and if possible the ESB also be done. Further, the detainee shall report to the officer in charge of Paltan Bazaar police station once every week or may be required by the officer in charge, and the officer in charge shall be responsible for keeping track of his whereabouts. In the event there being any change of address where the detainee upon being released would reside, the same be informed to the officer in charge of Paltan Bazaar police station, who shall do the needful so that the same terms and conditions can be made applicable in respect of the police station where the detainee may in future decides to reside. The release of the detainee shall be taken note by the Superintendent of Police, Border Assam, release the matter so and so along with other batch of you for adjudication in the institution. Similar, I am also similarly placed there. Yes, madam. May I just summarize the entire circumstances? That was not all long. I don't want to that's not my intention. If your lordship wants, may I request to submit written statements or written arguments also, only to assist my lords. That won't be possible. Yes. So in short, just I have six broader grounds in which I am before your lordship. I'm just summarizing. First is like minutes with prolonged detention, violation of under Article 21 minutes. And second minutes, entitlement to release as per the Honorable Supreme Court's order of bail, SCLC versus Union of India. Third minutes that I have been granted exemption under 2015 notification and Immigration and Foreigners Exemption Order 2025. Four minutes that I am covered under CAR 2019. Fifth minus, there is a statutory bar on deportation without nationality verification. Since 10 years, they have not done any nationality verification. So minus, whether they are even interested, I'm just been, they lodge me in detention and they forget me. So that is also minus one thing. And the fifth is that everyone, all of my family members, my wife is an Indian, all of the family members are Indian minus. I also have some entitlement to family life. So in that sense, I may be a stateless person. So this is my sixth argument before your lordship. Only just last thing is will take into consideration your lordship whatever your lordship decides. If a person commits a murder and he is sentenced to 20 years of jail, he is a criminal only for the 20 years when he is in jail. But my lord, a person, this is an ex parte case in which I receive a notice and I somehow, for reasons, even for my own fault, let's for sake of an argument, let's assume it. And I don't go before the foreigners tribunal, my entire life has been criminalized. The criminality is attached to my personhood. So that is my entire idea, the entire submission. That is what. Yes, sir. Criminal proceeding. FT is a civil proceeding, but if section 14 CGM, it is a criminal proceeding. Because I am CGM, I have been convicted by CGM court, no? So that is it. Yeah. Yeah. Subsequently, it was turned into a criminal proceeding. I understand. Yes, yes, ma'am. Yes. Yes, your lordship is right. That is not for life, but the situation is such. For 2 years. No. Well, this is only one. Just one thing, madam. Just one thing. What is my? I'm just clarifying. Because I'm 10 years there, and since I was okay, grateful.
Lordship petitioner seems to be a habitual offender, Lordship. He is a habitual offender. He was declared a foreigner, Lordship. He was pushed back. He came back. He is in jail. Lordship, it is here in the order. Justice Sharma's order, Lordship, at page 36. Lordship will see, Lordship, there are very clear directions in this order. At page 42, Lordship. Page 42 says, the writ petition is dismissed. Superintendent of Police Border, Gwalpara and DC Gwalpara shall ensure detention and deportation, pushback of the petitioner to Bangladesh and deletion of his name so and so. Lordship, on the next page, there is a, notice of his pushback. I just read it. He was pushed back. Lordship, I'll just, which page is it? There, no, the police had given a notice that he was pushed back.
35, that is.
Page 30, page 34, this one, no?
Yeah.
Uh,
submitted
At
before
page,
CGM.
yes, before the CGM Lordship, no,
Before the
before
FT.
the FT member, at page 35, if Lordship comes, the last order, 26/7/2010, respondent was pushed back on 9/4/2010 as report submitted by the border branch. He was pushed back on 2010 Lordship after this order. Page 30. One second. So Lordship, he was pushed back after this order passed by Justice Sharma. Then he again reappeared in India and a case was filed against him in the Judicial Magistrate First Class Gwalpara Lordship. The date of judgment is 25/9/2017, page 44 Lordship. The first paragraph itself says that he was a declared foreigner and he was pushed back to Bangladesh. Then Lordship, if Lordship comes to the submission, Lordship, the order, final order. Decision and reason thereof is Lordship. Yes, Lordship. In that joint answer. Lordships, the reason, decision and reasons of Lordships is the court has even appreciated the evidence produced by the prosecution. He was seen and again picked up by the police Lordship. And the final order is at paragraph 16 Lordship. In view of the submission made during sentence hearing, I am of the opinion that the person deserves to be viewed leniently and accordingly the convicted accused Uttam Das is sentenced to undergo RI for 2 years for offense under so and so. So the period has already undergone by the accused person during investigation and bail may be set off. Paragraph 17 says, in views of the directions given by the Honorable Gauhati High Court in its decision passed in so and so, SP Border Gwalpara is directed to take steps for pushing back the accused person to Bangladesh after serving out his imprisonment. So even this court has taken its stand on his return back to India Lordship. Then they have annexed some Supreme Court orders, but Lordship, the fact remains that he is a declared foreigner. No, ऐसा बोलो इसको करने के लिए. And Lordship, in the absence of the other conditions of the state Lordship, we have no instructions as to what happens once he's in detention for a long period. So, This forward regarding the expatriate thing. Proposition copy में कौन से document single document. No, it is by the modification direction. No, no, we copy file, we basically modification.
DK Agarwal, I'm a counsel for the petition and also for the respondents. That's fine. The petitioner is a declared foreign national by opinion dated 1/9/2009 passed by the learned member from our Foreigners Tribunal Gwalpara in FT case number 1039/G/06, thereby declaring him to be an illegal migrant entering into Assam after the cutoff date of 25/3/1971. Party opinion. It's party opinion. Too strong. Next, the petitioner had unsuccessfully assailed. He said ex parte opinion by filing a writ petition under Article 226 of the Constitution of India, which was registered as WPC 4903 of 2009. And this court, by an order dated 8/1/2010, dismissed the writ petition. Therefore, the said ex parte opinion dated 1/9/2009, as well as the order dated 8/1/2010, passed in WBC 4903/2009, has have attained final B. Full stop. The next one, the petitioner projects that the Court of Learned Judicial Magistrate, Gwalpara, took cognizance of the case on receipt of complaint petition, which was registered as CR-EPE 1/16 under section 6 within bracket small a of the section 6 within bracket small a of the passport within bracket entry into India bracket code rules from 1950, read with section 14 of the Foreigners Act from 1946. Accordingly, later on the proceeding was transferred to the Court of Judicial Magistrate first class Gwalpara for trial, and the petitioner was convicted by order dated 25/9/2017, passed by the Honorable Judicial Magistrate first class, Gwalpara. They were sentencing they were convicting the petitioner of the offense and sentencing him to undergo rigorous imprisonment for 2 years for offense under Rule 6 within bracket A bracket code of the passport within bracket entry into India bracket code rules from 1950, and rigorous imprisonment for 2 years and with fine of ₹2,000 with default clause for offense under section 14 within bracket small c of the Foreigners Act of 1946, and both the sentences were granted to run concurrently. The set-off of the period already undergone. Of the hold on. Next slide. the General Counsel for the petitioner has submitted that the petitioner has suffered a prolonged detention since he was taken into custody on 2/11/2016. Accordingly, by relying on the order dated 10/5/2019, passed by the Supreme Court of India in the case of WP within bracket civil bracket close number 1045 of 2018. The petitioner claims entitled to bail. Full stop. It is further submitted that the petitioner is entitled to exemption from being sent back to the specified territory under the provisions of the Immigration and Foreigners Act, 2025. Which clause of this, which section of this?
The exemption. There is a separate exemption order, Immigration and Foreigners Exemption Order 2025. At page 171 of my compilation.
Not under the Immigration and Foreigners Act, but you say it is Immigration and Foreigners Order, 2025. Moreover, it is submitted that the petitioner is covered by the Citizenship Act Amendment. Citizenship within bracket Amendment Act.
Page 12, I have summarized of my petition. Page 12. Para 23. And 22 starts. From page 11 from para 22.
For the projecting that the state provisions are required to be read together with orders within bracket amendment, bracket close order, 2014, and passport within bracket entry into India, bracket close amendment rules, 2015. It is also permitted that the petitioner is a Hindu and belongs to minority community in Bangladesh, would be entitled to the exemption. Full stop. Next, it is further submitted that despite being incarcerated since 2016, the state has not taken any steps for the deportation of the petitioner to Bangladesh, and therefore he is entitled to bail. So moreover, comment is submitted that the petitioner also has a fundamental right to be entitled to a family life. And in this regard, it is submitted that the petitioner has a spouse. And how many children?
Is it page Page 67 is the registration.
Page
67.
67.
The type copy is the subsequently.
Sequence. And the wife of the petitioner, namely Barcelona Branch BAS has applied for registration under section 6, capital A of the Citizenship Act of 1955. That's accordingly covered by filing this petition under Article 226 of the Constitution of India. The petitioner has paid for issues of writ, order or direction upon the respondents to allow the petitioner to apply for citizenship under the Citizenship within bracket amendment bracket 4 Act 2019 and to order release of the petitioner from the detention, you are at detention camp.
Now
That is,
it is
the
called
transit
holding
camp.
center. Now it is called as holding center.
Holding center at
Matia.
Matia Gauhati on bail on such conditions as we will anticipate and to pay the deportation of the petitioner. That's para. We continue dictation post transfer. Hello. The per contract of the Runner Standing Council for the Water and FT matters has opposed the prayer and made us some submissions in support of the act taken action of the state government in apprehending the petitioner and to detain him at the holding area, pending expulsion. Next paragraph. No, next, same paragraph. It has been submitted that the end of annexure 1 to the rate petition, the learned member, foreigners tribunal number 1, Gwalpara, had recorded to the effect, had recorded in the order sheet to the effect that the petitioner was pushed back on 9/4/2010 as report submitted by the border branch. Full stop. It is submitted that from annexure 3 to the writ petition, which is a copy of the judgment and order dated 25/9/2017, passed by the learned judicial magistrate, first class, Gwalpara. This is page 44. In capital CR dash PPE space 1/16, the said learned court had recorded the evidence of PW3, which stated that the petitioner was a declared foreigner and was pulled back. Full stop. Thus, it is submitted that even after his expulsion, the petitioner had had returned back into the territory of India, and on 2/11/2016, at about 1 p.m., the petitioner was apprehended from Molaundubi, MOLAUNDUBI, Tinali, and accordingly, the petitioner was convicted and sentenced for committing offence under section 6 within bracket small a of the passport within bracket entry into India bracket rules, 1950, read with section 14, as well as section 14 within bracket small c of the Foreigners Act, 1946. It has also been submitted that when the Supreme Court of India as well as this court had passed orders from time to time during the COVID-19 pandemic period so as to decongest the jails and holding areas of the declared foreign nationals, and as the COVID pandemic situation is not continuing presently, state would have inherent power to keep the petitioner in the holding area pending his expulsion. Next para. The materials available in the writ petition, including the compilation of statutes, rules and judicial pronouncements, filed by the learned counsel for the petitioner has been perused. Next paragraph. There is no material available on the record which could effectively counter the contents of the order dated 26/7/2010, recorded by the learned member, foreigners tribunal, tribunal number 1, Gauhati, to the effect that the petitioner was pushed back on 9/4/2010. Full stop. The petitioner was again apprehended into in the Indian territory as recorded in the judgment and order dated 25/9/2017, passed by the learned Judicial Magistrate First Class, Gauhati in CR-PPE space 1/2016. Full stop. It is also not in dispute that the opinion dated 1/9/2009, passed by the said learned tribunal in FT case number 1039/G/06 against the petitioner has retained finality after dismissal of the challenge made by the petitioner by filing WPC 4903/2009, which were dismissed by order dated 8/1/2010. Stop. Further challenge, if any, to the order of this court dated 8/1/2010, passed in WPC 4903/2009 is not, if made, is not disclosed in the writ petition. Full stop. At this stage, it would be appropriate to refer to the historical background of the foreigners issue flagging the state of Assam. Full stop. The issue of large-scale influx of illegal migrants from the specified territory, i.e., East Pakistan prior to 24/3/1971 and Bangladesh after 25/3/1971 is altering the demography of the state. Full stop. This led to a long dash drawn students' agitation in the state of Assam. Full stop. This issue of illegal migrants from the specified territory has elaborately been referred to in the case of Sarvanan Sonwal versus Union of India and others, within bracket 2005, bracket was 5SC 665. Full stop. The relevant paragraphs thereof are quoted below. This paragraph you take it from the letter on. From the therein before referred observations and decision of the decision in the case of Savarnan Sonwar within bracket Supra, it would be evident that in the memorandum of settlement between the Government of India and the All Assam Students Union, one of the clauses of the agreement was to the effect that all persons who were expelled earlier but have since re-entered illegally into Assam, shall be expelled. Full stop. Therefore, the state having detected the petitioner, declared foreign national to have re-entered into India is required to be expelled. Full stop. The next, the petitioner in this regard has taken to plea for the purpose of his release on bail, being the prolonged detention of the petitioner since he was apprehended on 2/11/2016, which is referred to in the order passed by the Learned Judicial Magistrate First Class in CR-PPE space 1/16. And the entitlement of the petitioner to bail on as per the directions contained in the order dated 10/5/2010 passed by the Supreme Court of India in WPC 1045/2018. Give a dash and then say Supreme Court Legal Services Committee versus Union of India and another. Next one. With utmost respect to the decision of the Supreme Court of India in the case of in the case of Supreme Court Legal Services Committee within bracket Supra, as reference has been made therein for deportation, the it appears that the decision by the Constitution Bench of the Supreme Court of India in the case of Hans Muller of Nuremberg, HANS, next word Muller, MULLER, third word of OF, Nuremberg, NURENBURG versus Superintendent, Presidency Jail, Calcutta and others, AIR 1955, SC 367, equivalent to within bracket 1955, bracket goes 0, Supreme within bracket SC 15. Would be appropriate to be referred to. Full stop. paragraphs 34 to 37, 40 and 41 thereof are extracted below. Full stop. Thus, the said decision of the decision of Hans Müller of Nuremberg within bracket supra confirms and reaffirms the absolute and unfettered power of the government to order expulsion of a foreigner. Full stop. In this case, the petitioner has already been declared to be a foreigner wide opinion dated 1/9/2009, referred above. In this regard, it may further be stated that in the rest of the country, except the state of Assam, it is the executive who can order expulsion of a foreigner or the illegal migrant. However, the illegal migrants who have illegally entered into the territory of India within bracket Assam, without any valid documents from the specified territory, are subjected to proceedings before the foreigners tribunals, and only after being declared to be an illegal migrant, such illegal migrants are subjected to expulsion from the country. Full stop. Next paragraph. The Supreme Court of India, in the case of Sarvanand Sonowal versus Union of India and others, 2005, Article 5 SEC 665, has equated the issue of illegal migrants in the state of Assam as to be to consider that the state of Assam is facing external aggression. In the said case, the Supreme Court of India has referred to two books which are referred to below. Let's take that after that books. Next paragraph. Therefore, this court is of the considered opinion that in the event a declared foreign national cannot be expelled due to any reason whatsoever, which includes the petitioner, perhaps the detaining of such declared foreign national in the holding areas earmarked for the purpose is the only way. Under the erstwhile Foreigners Act, 1946, the provision for that provision for such detention or confinement was provided for under Section 4 of the Foreigners Act, 1946, and similar provision is available in Para 12 of the Immigration and Foreigners Order, 2025, which empowers the state to impose restrictions on movement and for deportation of illegal migrants. Therefore, is the learned standing also for the foreigners and active matters has been able to show that the petitioner was expelled from the country and thereafter he had re-entered and was apprehended. Notwithstanding the prolonged detention, the court does not find the petitioner to be entitled to bail. Next paragraph. The other issue raised by the learned counsel for the petitioner is regarding an exemption under the Immigration, IMMI, GRATIN, Immigration and Foreigners Order, 2025. Mr. Agarwal, you are referring to which provision there?
Regarding?
Which provision you are referring to for your exemption under 2025 order?
Immigration and Foreigners Exemption Order. I have
Where is that?
para 3E.
CE of that order. Please check up which
This one. At page 172 in my compilation.
172.
And I have also referred to it in page 12 of my petition. I have quoted the entire provision. Page 172.
Just a moment.
The date has been changed. Yes, then my, yes, sir. Refugee certificate. I have annexed it. Pay, mm, page 52, ma'am, to my grandmother. My name is also there in the voter list from 85. That is also I have annexed. Yes, sir. Refugee. I have the original with me. If my lords want to produce, I can.
making an attempt to make your statement, what you call, what was your statement, to summarize your argument. You should have shown this 52 first. This, and this page 53 first, and this refugee certificate. Come to page 53. This alters everything. We are aware on which provision these are issued. No, that's the difficulty. You have this book, Mr. Sharma. Come to page 184. Yes, come to section 2. Expulsion of certain immigrants. Then come to proviso after AB. In the proceedings before the judicial magistrate first class, as well as before this court in the writ petition, you never introduced this document and never introduced your grandmother. Why should we believe on this?
Yeah, I mentioned when in 1952, my grandmother came. I began through that. Yes, that's it. Mm. No, ma'am, that is not with me. Otherwise, in the order, in the learned single judge order, it is not mentioned. In the learned single judge order, it is not mentioned. No, okay. Just one, if my lord is thinking in that way, so if the expulsion order will pass by the DC, so DC, before DC can examine whether this is a true document or not. Hmm. 54, 53. The next day four.
Issued on 14
10,
10 1952, certifying that one Giri
Bala,
Bala
Mali,
hmm,
Mali. I have the original
Mali.
with me. My points.
had with his 3 family members of village
Delhi Ali.
Deliali, Delhi Ali, Thana, what is it?
Saturia.
Saturia, Saturia, in the district of Dhaka, Dacca.
No, it's person.
Is now in village
Howli.
Howli, Moza,
Howli.
Howli, within bracket Assam. Is a displaced person from East Bengal in the register of inverted commas new oblique inverted comma old displaced persons maintained in the office of the SDO, comma Barpeta. So stop. Accordingly, comma, it is claimed that the person in whose name the refugee certificate is made is the grandmother of the petitioner. Just give that document. जो ऊपर की बात wife of
At that time of time, in that area, there was a refugee camp was established, and then all the people in
we
Sudan, they
don't know about it. So stop. Though the document appears to be of some value, as such certificates are usually issued under the powers conferred under proviso to section 2 of the immigrants within bracket expulsion from Assam bracket goes Act, 1950, yet, the court cannot take cannot rely, but the court, in this case, cannot rely on the said document because from a perusal of the order dated 81/2010 passed by this court in WPC 4903 of 2009. Comma. The said document is not found effective to stop. Moreover, comma. From the content of the judgment and order dated 25/9/2017 passed by the learned judicial magistrate first class, Goalpara, in CR-TPE space 1/2016. It does not appear that the said document was relied upon by the petitioner in his defense. Full stop. Therefore, next slide, therefore, comma. The issue raised by the petitioner regarding exemption, comma, if any, under the Immigration and Foreigners Order, comma, 2025 cannot be examined at this stage by this court. Full stop. The next point urged by the Honorable Counsel for the petitioner is regarding the applicability of the Citizenship within bracket amendment bracket act. Full stop. In this regard, it would be appropriate to refer to the in this regard, just a moment. In this regard, it would be appropriate to refer to the decision of the decision dated, sorry, judgment and order dated, that CA judgment is, what is the date of that judgment? Uh,
There's a 2020, I can citation. 2024 INSC 789. And date is 17th October 2024.
Judgment and order dated 17/10/2024, passed by the Supreme Court of India in column, section 6, capital A of the Citizenship Act, 1955. Full stop. You say in this case, in the, it may be appropriate to refer to the case of decision related so and so of the Supreme Court of India in the case of in Section 6A of the Citizenship Act. Stop. In the said case, at sorry, in paragraph 218 within bracket small d, the Supreme Court of India has held that give a dash in inverted commas, immigrants who migrated between 1/1/1966 and 24/3/1971 within bracket both inclusive bracket close, and who have been detected as foreigners but have not registered themselves with the registering authority within the prescribed time limit as per the citizenship rules, 2009, will no longer be eligible for the benefit of citizenship. Stop. Therefore, next paragraph. In this regard, the learned counsel for the petitioner had submitted that the said observations made in paragraph 218 within bracket small d was a minority view and not the residency of the case. Full stop. We are constrained to full stop. In this regard, this court is of the constitutional opinion that when a point is decided by the Supreme Court of India, notwithstanding that the said part was authored by one honorable single judge, the said view cannot be said to be a minority view when the learned single judge had concurred with the majority decision to stop. The court is unable to accept that when appreciating the decision of the Supreme Court of India, majority view, which does not decide the point, decided by the learned single judge, would not be a decision of the bench. To stop. Therefore, the court is of the considered opinion that once the petitioner has been declared to be a foreigner by virtue of opinion dated 1/1/2009, referred above, the same does not call for a judicial order of this court to grant any leave to the petitioner to register himself as under the under the provision of 6 capital A of the Citizenship Act. Next, the other point raised by the learned counsel for the petitioner is that the state, till date, has not taken any steps for his deportation. In this regard, the court would only refer to the decision of the Supreme Court of India in the case of Sagar and Sonwar within bracket Supra, where the where reference has been made to the terms of settlement of the Assam Accord. The memorandum of settlement which was signed on 15/8/1985 by the President and General Secretary of the All Assam Students Union and convener of All Assam Gana Parishad on one hand, and the Home Secretary, Government of India, and the Chief Secretary, Government of Assam on the other side, which was signed in the presence of the then Prime Minister of India. Full stop. Clause 5.7 of the said agreement specifically referred to the effect that, inverted commas, all persons who were expelled earlier, but have since entered illegally into Assam, shall be expelled. Full stop, inverted comma closed. Full stop. In this writ petition, which is filed by the petitioner, the court does not intend to pass any orders adverse to the interest of the petitioner, and therefore no further observation is made in this regard. Next paragraph. The last plea raised by the learned counsel for the petitioner is regard to his entitlement to a family life. Full stop. In view of the discussions made here and before regarding the section 4 of the Foreigners Act, corresponding to section 12 of the as well as not corresponding, as well as section 12, order 12 of the, not order 12, it's para 12 of the Immigration and Foreigners Order, 2025, the state would have unfettered powers to keep the petitioner at a specified place till could be deported. Next para. Accordingly, the court does not find any merit in the writ petition, and accordingly the same is dismissed. Next para. Nothing contained in this order shall nothing in these orders have people the right of the petitioner to to take his claim to agitate his grievance to agitate his grievance based on the refugee registration certificate dated 14/10/1952, which has been produced before this court for the first time. Next paragraph. Accordingly, this is dismissed. There shall be no orders to cost. We still give you that liberty of this document.
Yes, with respect to 6 events, I have two submissions. My one submission was also this one, is that prescribed limit. The honorable judges, they use the word prescribed limit regarding registration within the prescribed limit as per the Citizenship Rules 2009. This is only with respect to the 6A. So that is was also one of my submissions. Is that all?
Which we have already referred to.
So then- Great, present.
So to the members of the bar, including the study council for FT and border matters, since we'll be rising early, this hearing which has started on this ex parte opinions, that will continue. In a day or two, I will ask the registry to refix it in some other day within this week. Because tomorrow the list is already out. We have to adjust these matters. There was a request to upgrade one matter that was also ex parte. It will come on the same day, whatever is left out of those ex parte opinions. I would request all of you to please indicate this ex parte opinion to the court master after we leave, so that those matters can be listed again. Not one day after tomorrow, Thursday. Huh? Yeah,
The Thursday, my lord, my person was in jail. Thursday.
We'll take it up, just let the court master take it up, because we can take up one more matter. We have had this time till.
Item 7.
May I please the lordship? Lordship, here it is expert order. Impugn order at page 47.
But that was in 24. What is the explanation for 2 years?
My lord, I have given an explanation that due to financial condition, she could not appear, could not approach the full dishonorable court in due time.
So that would not be a good ground. We are giving the free legal aid.
My
The
lord,
state is spending a lot of money in free legal aid.
the petitioner is illiterate and she is not aware of this facility that legal aid is available. So at this stage, my lord, I pray for lenient view in it concerning with this delay, my lord. And this is an expert order, and
You took a plea of illness. What was your illness that you are not treated?
my lord, yeah, in the adjournment petitions, it is serious illness, but not specifically mentioned whether what is the illness is there. But in my writ petition, I have subsequently given this reason that she was suffering from jaundice and
No, you see that
Other-
would not help you. The reason is come to page 55.
my lord.
Read this adjournment petition, third line. But the opposite party informed the advocate over cell phone that she is suffering from serious illness. So you
Yes.
have a cell phone and you can communicate through the cell phone. So therefore, there was no reason that you were not aware of the date.
She informed,
So
to her
therefore,
counsel.
6/3 you informed.
Yes. It was informed and,
So
on
therefore
4
you-
consecutive dates, adjournment
That's
was
okay,
there.
but the fact is that you show here that you have a cell phone. And therefore,
Cell phone is my lord,
the,
having.
no, we don't know, you see, you said that you are not there, you're not aware. But you are communicating, that is your admitted part.
That is, my lord, mere connection is with the council, but, petitioner is not,
No,
so.
no, this also means that you
Well,
have the
what-
phone number of your lawyer.
That is true.
So
that,
for 2 years, you have no explanation why you did not contact your lawyer and you could not file your writ petition.
That is, I have stated that financial condition only, my lord.
It's not a case of financial condition.
And,
You came to know about it when?
my lord, in the interim order that, written statement was filed, but,
So that's okay. You see, when I can read this small petition, in your writ petition, that far you must assume that we are aware. In your writ petition, whatever you stated, on which date you came to know about about this ex parte opinion. So you don't say about the date on which you came to know about the ex parte opinion. Now, this ex parte opinion was passed on 12/6/2024.
no,
You applied for certified copy on 7/10/2025. You got it on 16/10/2025.
yes.
From 16/10/25 till the filing of this writ petition on 16/6/25. What is your explanation? There is none.
My lord, in this case, what happened that she approached before this honorable court, previously with another writ petition that was subsequently that was withdrawn, my lord.
Where is that?
Yes. Earlier writ petition was, my lord, 1017/2016.
Which page?
I have not, given here the details, my lord. 1017. 2000.
Where is your statement in the writ petition?
My lord, that was withdrawn with the liberty to file a fresh, my lord.
Which paragraph is your statement?
Statement I have, my lord, not given here, since, liberty is there, my lord, to file this afresh, my lord. And, in that case also, my lord, there was a delay, my lord. It was
No, but if
filed,
you withhold it, we don't have knowledge of your earlier writ petition.
yes, yes.
You don't make that disclosure. No, then you have to wait till Mr. Sharma makes his argument.
My lord.
The day after tomorrow, we are trying to have it fixed. Day after tomorrow, ex parte, sir. All ex parte matters, we are listing it. Other matters would be coming after that. Before this court or before the notary here, please signed affidavits were prepared to file this writ petition.
My lord, thereafter it was withdrawn, my lord, due to that reason.
Even this, we don't remember.
My lord,
This affidavit also was signed, not in the presence of the notary.
it was signed before the notary, my lord.
No, it can't be. We have reasons to say that.
My lord,
You see, we don't accuse so easily.
my lord.
When we are doing it, that means we are very certain of it. We'll show you what has happened.
My lord.
It too. Video.
Well, she came in front of me and signed before the notary, but what?
She did not come. We are certain of it. No, both you have to look at together.
My lord,
Come to page 13. That is your affidavit,
happened.
correct? Below that affidavit is, the spelling of deponent is wrong. That's number one. Second is, in the second judge copy, page 13 is a crumpled page. Correct. That one, this was discarded and thereafter retrieved from the dustbin, ironed and then filed. Why would that be done if the deponent is here? Mr. Das, be certain of what you are doing. When we say it is a manufactured person, we have very strong reasons to say that. Otherwise, a crumpled paper would never be presented before the High Court.
But my lord,
Don't do it. At times,
Bona fide
everything, when we can refer to a statement in the adjournment petition, please understand when we look at the documents, we look at very seriously. Don't, it will cost you,
but
it may,
with bona fide,
it
my
may-
lord,
it may cost you time.
bona fide conclusion, I'm saying that, and it is my humble submission that he came to Guwahati and signed before me, my lord. That is
No,
bona fide.
if that document is crumpled, why could you not get
My lord,
another one?
that is in the clerk.
No, that's not there.
Show that page, what,
It's never there.
my lord,
There is a second reason to say that.
my lord.
You see, there is a difference between the writing and the signature.
Signature, my lord, signature is similar, but the deponent it is written by, one is written by advocate and another was written by clerk, my lord. That is
Advocate wrote the spelling of deponent wrong. Very good.
deponent, yes, my lord.
Clerk-
I'm very,
clerk's English
very
was
much
right.
sorry, my lord, on this case.
It's okay.
Yes.
Wonderful things we hear here.